Welcome to Human Rights Uncovered, a podcast from the Geneva Academy of International Humanitarian Law and Human Rights, a joint centre of the University of Geneva and the Geneva Graduate Institute.
Hello and welcome to the second episode of Human Rights Uncovered. In this podcast, we explore the major human rights questions shaping our world with experts and practitioners working at the heart of these issues. Our goal is to advance understanding and stimulate discussion on subjects that are legally, politically, or ethically significant and often uncovered. In the previous episode, we explored what neurotechnologies are, how they work, and how they are already transforming medicine and challenging our rights. In this second episode, we move one step further, looking at power, risk, and regulation. What happens when neurotechnologies leave the clinic and enter our everyday lives? And why this raises genuine human rights concerns. We will also explore how governments, United Nations bodies, and researchers are responding and why concepts like neurorights are now part of a global debate. To guide us through this conversation, I'm once again joined by two experts. First, I would like to welcome Dr. Jonathan Andrew, former research fellow at the Geneva Academy of International Humanitarian Law and Human Rights, and a lawyer with over 25 years of experience working on technology, health, and international law. Secondly, I'm very pleased to welcome Dr. Karen Herrera Ferra, neuroethicist and the founder and former president of the Mexican Association of Neuroethics, with extensive experience in bioethics, neuroethics, and behavioral therapy. Jonathan, Karen, thank you so much for joining us today. I'm Clémence, your host, and this is Human Rights Uncovered. Neurotechnologies are no longer confined to clinics or laboratories. They are moving into everyday life, into consumer products, workplaces, schools, wellness apps, and even entertainment. And that shift fundamentally changes the power dynamics around these technologies. Jonathan, I would like to start by asking you, what does it mean for society when neurotechnology becomes a consumer product rather than a clinical tool?
Well, I think one of the key challenges is just in terms of consumers' understanding of what neurotechnologies are capable of, what using a device with neurotechnologies incorporated actually means for them in terms of subsequently how their human rights might be affected. There's a key challenge insofar as many people won't understand what kind of data collection, data processing activities are taking place in relation to their use of the device. So there's a clear question around explainability, around transparency, around basic rights in terms of knowledge and understanding of the implications. There's certainly a power dynamic in play here in terms of increasing gap that we see with many consumer technologies in terms of understanding what sort of privacy implications are engaged, also in relation to other rights, in relation to freedom of expression, freedom of thought, freedom of religion. We're seeing increasingly this gap is widening. There are also implications in terms of, depending on the jurisdiction, the country in which you live, how the data that's collected and processed may be accessed by different parties. So there are concerns here, for example, regarding surveillance by state authorities, public authorities, law enforcement, intelligence services in different contexts. And there we have, in some countries, safeguards regulation. Questions arise as to whether that regulation is sufficient.
Listening to you, I keep thinking that the biggest risk might not come from a sudden dystopian leap, but from something much more familiar. Like with AI, we've seen how technologies become unavoidable, not because we truly need them, but because companies design systems that makes us feel we can't function without them. I was struck by this recently in a very ordinary way. My mother asked my siblings and I to activate the location tracking on our phones, not to control us, but simply to feel reassured. But it made me think of this Black Mirror episode like Archangel, where a mother decides to implant a chip in her daughter's brain to track her location and even see through her eyes, also in the name of safety. Of course, my mother would never want to implant anything in my brain, but the logic is not entirely different. Like, we have already accepted giving technology a huge place in our lives, and often for very understandable reasons security, care, efficiency. So the question isn't always about bad intentions, it's about where we draw the line. We already live in a world where we constantly share personal data online, location, habits, preferences, often in exchange for convenience. Today, big tech companies are developing neural earbuds, attention tracking headsets. These tools can infer mental states like fatigue, focus, or emotional reactions, often without users fully understanding what kind of data is being captured. Karen, from your point of view, what concerns you the most when brain related data starts being collected in everyday, non medical contexts? And do you think our thoughts can really be treated as data like any other?
The thing is that neurotechnology cannot read what you are thinking or what you are feeling, but can read like states, right? So it can say, okay, she's thinking about something positive, but we cannot say exactly what you are thinking. Nevertheless, this very private and intimate information can be obtained. And again, we need to make sure that neurodata is understood as personal sensitive data. That means that you can be identified by this information, by this data. So, yeah, this is a huge concern about how this data will be used, because again, this is not demographic data or like data that will not identify, but it is personal sensitive data. That is data that I don't even know that I how I think or how I feel or what are the triggers that make me mad. And then you are going to have this information, and it will be again it will feed AI, it will feed algorithms, it will shape my social media. Or yes, that's a huge threat to privacy, to autonomy, maybe even to agency. So we need to be very aware and consciousness and active regarding how are we going to use this. Like, if you want to have this data, you have to make sure why do you want it. Is it going to be for medical purposes? Is it going to be for political reasons? Is it going to be for discrimination?
In hospitals, neurotechnologies are used with strict rules, medical oversights, and informed consent. But once these technologies leave the clinic, those safeguards don't always follow. Jonathan, from a legal perspective, where do you see the most serious and plausible risks emerging, especially outside of medical settings? You mentioned it earlier, for instance, in areas like law enforcement or surveillance.
So I think a key point is to take into consideration that we've seen developments in the area of data protection and privacy laws in many jurisdictions, particularly after Europe implemented the General Data Protection Regulation, the GDPR. We saw many other regions and countries following that lead and implementing new laws. But there are still, in many countries, many regions, some oversights, some areas where health data processed in a way that leaves much to be desired. There's still some serious challenges around data security practices, both in the public domain and private sector in healthcare. And we also see this mirrored in other areas around the use of consumer devices, consumer protection law, There are gaps. There are insufficient safeguards, mechanisms in which people who are using these products can actually raise their concerns, press for remedies where they've had their rights to privacy interfered with. Many of these technologies, it's not necessarily clear. The data that's being collected will be for how long it will be retained and whether it may be repurposed, reused for other purposes other than for the specific purposes that the user had thought were implicated.
I have seen that in criminal justice, some jurisdictions are exploring brain scans to detect guilty knowledge. What are the dangers of using neurotechnologies in investigations or courtrooms?
It's an interesting area because we've seen in the area, for example, of examining activity in the brain, we see functional magnetic resonance imaging, fMRI, being used in more and more places where the technology is more accessible, more available. We see the costs of using these technologies coming down. I remember from my own experience having an fMRI scan over 30 years ago, and it was incredibly expensive. There are very few MRI scanners available in a clinical setting. Now they're more pervasive, but I'm speaking here from the privilege of living in a country where we have quite well-developed healthcare system. That's not necessarily the case, obviously, the world over. I think one of the challenges is that there are always thoughts that we can use technologies like neurotechnologies in novel ways without necessarily understanding some of the biases and implicit deficiencies that are present in those systems that have been developed, where there have been oversights and insufficient regard has been paid to ensuring that we really know the limitations of the technologies, what we can infer from the results that we're gathering from their use. I think also a further concern, there's been a lot of talk around the criminal justice system, but I can already see a huge area of there being really insufficient research being conducted currently is in civil justice systems. So we see, for example, in immigration courts, I once worked in refugee law, we see questions arising in cases where people have to prove the veracity of their statements. And I can see in this area that technologies that claim to be able to ascertain whether somebody's telling the truth or not could be used in this context, so in the context of immigration tribunals. So I think it's really important that we also look beyond the criminal justice system. And I think this paradoxically might actually get more people interested in kind of discussing and resolving these concerns, because I think, ironically, when people see it might impact themselves. So in civil justice procedures, so in questions around property rights, around, civil disputes, which are much more commonplace than criminal prosecutions, they might actually feel that, for example, if they're involved in a car accident and they might be asked to take some sort of test to ascertain whether their claim of who was responsible for the car accident is actually truthful, then they themselves may feel actually this is an area that their fundamental rights are implicated. So it goes beyond just, a narrow section of the population, those subject to criminal procedure. I think this is where we need to sort of widen the net a little more and think about the implications for justice system in a broader sense.
I want to add that using technology for just what Jonathan just explained, we need to remember ourselves that we as persons are not neurocentric. That means that we are not only a brain, and our behaviors and our states, mental states, are not the result of only one part or a specific nucleus on the brain. That means that our behaviors and emotions and thoughts are not always a causality. That means just one thing that that's a cause of this area is the part of my empathy or my guilty, or so we are correlational. There are a lot of brain areas that are involved in a thought or in an action. So first of all, we need to understand that. So there is not going to be an image that will say, oh, here is the guilty nucleus. Yes, he's guilty. So we need to first understand that. And then the second part is that an issue that we currently have with neurotechnology on evaluation, which is we interpret what we see. So this is a subjective activity and depends of the person who is evaluating the image. So it is not the same an evaluation of the image of a senior radiologist that has been doing these interpretations for 30 years only in the brain, that an evaluation of a medical student or someone that usually interprets images of the lungs. So this is very subjective. This, if the person who is interpreting this neurotechnology or images has been working for 10 hours, then maybe the interpretation will be also biased. So I don't think that right now neurotechnology is in a position to be used in the legal or in the courtrooms. That's what I wanted just to add. Thank you.
Thank you both so much. That's exactly where the rights we discussed in our last episode, such as mental privacy, autonomy, freedom of thought, start to feel very concrete. And this brings us to the big question policymakers are now facing. How do we protect the mind itself and regulate these technologies? The idea of neurorights is currently gaining traction. In 2025, UNESCO has adopted its first global recommendation on the ethics of neurotechnology, and UN experts are warning that we need clearer guidance to protect mental privacy, consent, and freedom of thought. Karen, for our listeners hearing this term for the first time, what are neurorights in simple words?
Neurorights are human rights and principles that will safeguard the nervous system. Okay, mainly the dignity of persons and the mental and cerebral activity as well as the data. So it's more like the human rights of the brain, let's say, and the mind.
From my understanding, there's also an ongoing debate here. Like, do we need new rights or can existing human rights be interpreted to cover neurotechnology?
Yes, there are two position or postures. One, of course, creating the new human rights, and the other, extending the expanding the scope and protection of existing human rights. My view is that we need just to expand the scope and protection of existing human rights. I think that what we need to maybe just create these new concepts or reconceptualize principles or human rights such as autonomy on regards the free choice to use or not use neurotechnology to alter state of consciousness or even free will. The mental privacy, again, we need to make sure that we are talking about neural data and that this data is sensitive, personal sensitive data. So, expanding this privacy to mental privacy, and also the integrity and continuity, not only physical, but specifically mentally, so that we can safeguard personal identity, mental integrity, and also agency. Yeah, and also, of course, as we have been saying, AI is part of this dialogue and conversation because we cannot think life without AI. And so we need to make sure that there is not algorithmic bias regarding when they are designing AI. As we know, mainly all of the algorithms are developed on the global north, and there's more than 60% of the global population that is not included in this design and development of neither AI or neurotechnology.
So I think we have, by and large, an existing framework in terms of a legal framework that we can apply. We don't necessarily need to introduce new rights, but what I do think we do need to change or introduce in terms of shaping how the debate progresses is we do need to have a more inclusive discussion. We do need to have a more interdisciplinary approach to policy making, in the sense that from my own experience in discussions working with people of different backgrounds in the professional setting, working with neuroscientists, neuroengineers, working with ethicists, clinical practitioners, health economists, working on issues around affordability, access to neurotechnologies, philosophers, psychiatrists, working with a broader range of disciplines provides insights. And it also helps me as a lawyer working in the human rights sphere, really understanding what the limits are in terms of my knowledge, where I need to learn from others' experiences, and also question my own judgment, because I think that can lead to much better outcomes in formulating how to apply existing regulation.
I would like now to come back a little bit on your experience, Karen. Recently, Chile added neurorights to its constitution while other countries are exploring similar ideas. I know that you have worked with the Mexican government on the subject. Do you think that we are witnessing the start of a new global legal movement?
I think that we are. I think that there was, again, this hype on neuro rights because the first movement was the idea of creating new human rights. And then that was with the genius Rafael Yuste, with, I think it was because of him that we are now very worried about this issue. And then it was the work of Roberto Adorno and Marcelo Yenca, who were more on the side of expanding the scope of the current human rights. So, yes, there is this, at least in Mexico, I have to say that there was this hype. More than 20 bills were developed under the name of neuro rights.
And what would you say are the questions policymakers struggle the most with when talking about neurotechnologies?
First of all, exactly what a neurotechnology is and what are the risks that we are concerned about, and mostly what was needed to be protected. So when they say we need to protect agency or personal identity or the state of consciousness, I think we're still on this dialogue. That there is international dialogue to, again, find an agreement or consensus of exactly what we are worried about. So we developed a definition mainly on the anatomy and physiology, to protect anatomy and physiology, because since this is evolving and these are emergent concerns. These are concerns that we didn't think that we were going to be worried about, but this technology is evolving, then emergent concerns are arising. So we thought that what we need to protect, and to be a language that could be friendly for legislation and the judicial system, it will be more current to protect the anatomy and physiology of the central and peripheral nervous system. So I think that was one of the concerns, just explaining a little bit of neuroscience, explaining a little bit of medicine, explaining a little bit of philosophy. They needed to be like a education, so they could understand why and what and when we needed to be prepared. It was more like preparedness than precaution. So, yeah, we needed a lot of receptiveness from the Senate so they can be open to understanding and to make a responsible and ethical bill to protect the brain and the mind of person as well as animals.
I think one of the key areas just also to reflect upon is that of physiology. I think one of the things we need to have, front of mind is we're obviously all individuals, and various facets of our lives influence how we develop as individuals, how our physiology evolves. Also in terms of understanding different needs of neurotechnologies based on our lived experiences, our interaction with healthcare systems, aspects of our physiology, for example, if we're living with a disability, so based on differences in gender, differences in different aspects of people's body types, and also experiences in terms of they're being subject to different life experience, which can influence whether or not they develop, for example, different conditions. So we need to really think, I think, a lot more about how, when we have these discussions around neurotechnologies, that we make the discussion more inclusive in terms of ensuring we have people from different communities, from different parts of society, people of different backgrounds, from different walks of life, working with different socioeconomic backgrounds, people of different lived experiences, being able to be drawn into the discussion so that they can provide their input and share their experiences. We often see in the human rights sphere many discussions about vulnerable groups, ensuring that we have a dialogue, we include stakeholders, but we need to really enact that, make sure it actually takes shape and is implemented, not just see this as some sort of tick box exercise where we need to ensure that we have children involved, older persons, people with disabilities, people from minorities backgrounds, Indigenous people. I think we should also be working on this across human rights to ensure that, maybe neurotechnologies can be at the fore in that kind of discussion, to make sure that we do that sort of engagement more proactively and more effectively. Because I think in neurotechnologies, it's really important.
Absolutely. We were considering also, beliefs that as we have a lot of indigenous population. So in our definition, we also included the protection of mental and cerebral activity, and we developed another definition. The cerebral activity was mainly the electrical and chemical activity, and the mental activity was the cognitive processes, how we develop emotions, thoughts, beliefs, decision making, moral decision making, empathy. So we try to include all of these. But again, I think we haven't yet achieved the international and interdisciplinary dialogue and discussions and debates regarding neurotechnology and neurorights, and to be truly inclusive. I think not only on this arena, but I think that we haven't achieved a truly inclusion. So inviting people from other countries or cultures, I think that that's not inclusive, and we should be aware of it. But we need to be more competent and receptive on trying to understand the phenomenology or how other people lives the same event. So yeah, that's what I think we are missing a little bit yet.
If you could recommend one regulatory step that should happen immediately, what would it be?
That's a tough question. That's a very tough question. I think that I always think that education is the first step. So I think we need to, be proactive in educating the policymakers or people who make decisions. We absolutely need to start regulation that can be international but also adapted locally or regionally. Like an immediate one, I would say we need to have more dialogue, more interaction, more inclusiveness of what our real concerns are, and how can we extend immediately the current legislation or current protection of human rights. And then we can continue to achieve consensus on what we want to protect. I don't think that we should just keep doing this for a long time, because it's already happening, and we are going to be too late or just regulating to solve a problem. And I think that we can now, in this moment, anticipate and regulate anticipatory concerns and issues.
I would say, firstly, I think foremost, we need to reflect on how we can develop more opportunities for neuroscientists, for medical ethicists, and for human rights lawyers to get around the table and have informed debates that draw on these different perspectives so that we have lawyers who better understand the science. We also have ethicists contributing in terms of like unpackaging some of the moral and ethical dilemmas, because I feel that's really important to informing the discussion of human rights, to really understand what human rights involves, not just on an abstract basis, but on a day-to-day basis in terms of what their implications are for how people actually live their lives in the real world. I think also another area in which we could do more, and it's imperative that we make more progress, is engaging with the companies, and beyond the companies also the healthcare systems, the research mechanisms. I'm thinking here of scientists and engineers involved in the universities and other institutions that are conducting research to better understand each other, have discussions where we can inform ourselves to the point around educate those people involved in the policy making. Humble in terms of understanding what the limitations of our knowledge are and where we need to increase our knowledge and expose ourselves to different views and perspectives. So we have a more holistic, more well-rounded view of the challenges. And I think that will really help. I think also a key area is in the area really of developing ways in which we can better engage with the public and do more outreach in terms of raising the issues that arise from the use of neurotechnologies. So I think this podcast is obviously a very good way in which to reach a wider audience. But I think perhaps there's other types of media, there's other types of publication, blogs, seminars, discussions that we can think of creatively in terms of just reaching out and building an awareness of the challenges, but also finding ways we can solicit feedback and understand what citizens, people in the street are actually thinking, what also might be their desires, wishes for innovation, so that can actually shape what's happening in terms of how the technology is evolving, being developed, and how the science is being applied, so that it isn't just sort of a top-down approach. It's one where we actually, as a society, discuss and shape how technology is going to be evolved and implemented. So it isn't just like a fait accompli. It's actually a more inclusive process in which we're shaping technology's development, because it isn't inevitable. Technology is shaped by us as humans. It doesn't come from the ether. It's something that we design and create ourselves as a society. So I think there needs to be more thought given there to how we can do that more effectively and gain control. I think that's the paradox in terms of human agency, is having the agency to shape the technology, not vice versa, not the other way around.
Thank you so much. This was extremely interesting. Listening to both of you, one question really stays with me. How do we protect the human mind, perhaps the last truly private space we have left, without stopping innovation that genuinely improves lives? Neurological and mental disorders are now the leading cause of illness and disability worldwide. As we have seen, the potential of neurotechnologies to treat these conditions represent an enormous source of hope for millions of people. But once they move beyond medicine, they also raise unprecedented questions about who can access our mind, who can influence it, and for what purpose. What's encouraging, though, is that researchers, clinicians, ethicists, and human rights experts like you, Jonathan and Karen, are actively working to anticipate risks, clarify responsibilities, and build ethical and legal safeguards at the international level. The debate about neurorights and regulation is not about stopping innovation, it's about guiding it so that neurotechnologies serve people, protect dignity, and strengthen human rights. Jonathan, Karen, thank you both very much for helping us unpack this topic and for joining me on this series of episodes on neurotechnologies and human rights. And to our listeners, if this conversation raised questions for you, that's exactly the point. Until next time, this was Human Rights Uncovered.
You've been listening to Human Rights Uncovered, a podcast from the Geneva Academy of International Humanitarian Law and Human Rights, a joint centre of the University of Geneva and the Geneva Graduate Institute. Find us at geneva-academy.ch and subscribe wherever you get your podcasts.